हेलो फ्रेंड्स, नमस्कार। कैसे हैं आप? हैप्पी न्यू ईयर टू ऑल ऑफ यू। आई वेलकम ऑल ऑफ यू on my YouTube channel. Today we are going to discuss about suspension of sentence and suspension of conviction. Are they same or are they different? Is there any provision? Is there any express provision or any implied provision? What is the law in respect of suspension of sentence and suspension of conviction? We will discuss in today's discussion. Let us move to the topic. Friends, if an accused person is facing a trial, criminal trial, he is called accused. He is presumed to be innocent unless he is held guilty by a competent criminal court. Once a competent criminal court holds him guilty, then necessary consequence is the order of conviction, and thereafter comes sentence. See, holding someone, that accused person, guilty, and thereafter awarding him the order of conviction and then sentence. If somebody is not convicted, question of sentence will not come, and therefore in order to sentence someone, to award punishment, he is necessary to be held guilty by the criminal court. And therefore today's topic plays very important role in understanding, can accused person, the person who is held guilty, a convict person, be enlarged on bail even after holding him guilty, even after the order of conviction. See, friends, the provision contained in the Code of Criminal Procedure are very much clear in this regard. Now let us move to section 389 of the Code of Criminal Procedure. Section 389 of the Code of Criminal Procedure provides for suspension of sentence during pendency of the appeal, and it further provides for release of appellant. Appellant means here is the person who is held guilty, who is convicted by the trial court, and thereafter, after his conviction, that person has filed an appeal, and therefore he is appellant here. Section 389 subsection 1 provides the power of the appellate court in respect of suspension of sentence. Now see, appellate court may, the word may is used. It is not mandatory for the appellate court to sentence, suspend in all cases. For reasons to be recorded in writing, order the execution of the sentence or order appeal against be suspended. And if he is in jail, he can be released on bail. Or if he is already on bail, he can be further directed to be enlarged on bail by accepting the bail bond. These are the powers of the appellate court. Subsection 2 provides the powers of the High Court in respect of suspension of sentence awarded by any subordinate court, with the subordinate courts which are subordinate to that concerned particular High Court. Subsection 3 provides the powers of suspension of sentence by the trial court itself, means the court which holds him guilty. See, the court which holds him guilty has power to suspend the sentence. There are certain conditions. Condition number 1, if the person is on bail and imprisonment is only for 3 years, not exceeding 3 years. It means if an accused person is convicted for more than 4 years or 5 years or upwards, the trial court shall not have power to suspend the sentence. If the punishment is not exceeding 3 years, then and then only accused that convict person can be released on bail or his sentence can be suspended. Second condition, where the offense of which such person has been convicted is a bailable and he is on bail. In that event, the learned trial court can sentence the suspend. So these are the powers. See, subsection 1 provides the powers of the appellate court to suspend the sentence, whereas subsection 3 provides the power of the trial court, means the court by which he is held guilty has power to suspend the sentence. These are the provisions of suspension of sentence, means even after holding the accused person guilty, he can be released on bail, number 1 by the appellate court, number 2 by the learned trial court. What about the suspension of conviction? There is no word suspension of conviction expressly used in section 389. Now see, suspension of conviction, friends, the court has certainly power to suspend the conviction, but in appropriate cases, not as a routine matter. And while exercising the powers, the court has to see the gravity of the offense, the evidence available on record, where there are chances to maintain the conviction or not, the conduct of the accused during the trial, repercussions of convictions. For instance, if a person, a public servant, is found guilty of corruption, he is sentenced. He has filed appeal. His sentence can be suspended. Of course, it is the discretion of the appellate court, but the appellate court may not suspend the conviction for the reason, if a person who is guilty of corruption, can he be continued in the public service as a government servant? Certainly not. And therefore, it will not be fitness of the things to continue him to discharge his duties as a public servant, and therefore his conviction is not liable to be suspended. And therefore, it is held in catena of decisions by the Honorable Apex Court as well as the High Courts that the court should be slow in suspending the conviction, but there is no complete bar in suspending the conviction. In exceptional cases, such powers can be exercised by the court. Now, move to the consequences of suspension of conviction and suspension of sentence. Having been noted the provisions from the Code of Criminal Procedure, now let us see the consequences of this suspension of sentence and suspension of conviction. Now see, suspension of sentence, it only suspends the sentence, meaning thereby the person who is convicted need not go to jail, or if he is in jail in view of the order of the learned trial court, the court by which he is convicted, he shall be released on bail. Number 1 condition we have seen, if he is convicted by the trial court and he is released on bail or his sentence is suspended by the trial court, he need not go to jail. If the sentence is more than 3 years, see, if someone is convicted and he is awarded the punishment of 5 years, trial court has no power to suspend his sentence. Definitely he will have to be taken into custody and to send him to jail. Now he is in jail, he is lodged in jail. That convict person prefers an appeal. Now the appellate court has power to suspend his sentence. And therefore section 389(1) comes into picture. The appellate court, looking to the evidence on record, the gravity of the offense, considering the chances of conviction or acquittal, may exercise the power and suspend his sentence. So during pendency of appeal, he will be released on bail. So as long as appeal is pending, he need not go to jail. But what if his appeal is dismissed? Then he will have to again go to jail. He will be either he will be surrendered or he will be arrested. So this is the provision. This is called suspension of sentence. Tentatively, he need not go to jail even after conviction. Now, what about the suspension of conviction? My friends, recently we have seen in the case of Rahul Gandhi that he was convicted and he was awarded punishment of 2 years, which is why it was possible, well within the domain of the learned trial court, to suspend his sentence. Accordingly, it was suspended. Appeal was preferred. Appellate court, the lower courts, what did? They suspended the sentence, but his conviction was not suspended. And therefore, his stigma of conviction was there. He was member of parliament, and as per the judgment of the Honorable Apex Court and in view of the provisions of the Representation of People Act, he suffers disqualification to be member of parliament because he is sentenced for 2 years. The moment a member of parliament is sentenced to 2 years, he is no more qualified to be member, and therefore he was ceased to be the member of parliament. But if his conviction was suspended, then what would have happened? Which is why he fought a lot. Matter ultimately reached to the Honorable Apex Court, and the Apex Court held that we see no specific reasons given by the learned trial court for awarding sentence of 2 years. And considering the evidence on record, the Honorable Apex Court suspend the conviction. So friends, as I explained you earlier, first step comes holding guilty, then order of conviction, then sentence. Here in his case, the Apex Court stayed his conviction and therefore question of sentence does not arise. Moreover, the moment his conviction was suspended, all the stigma, all the disqualification which is attached to his conviction are no more there until his appeal is decided by the competent court. The moment his conviction was suspended, he was restored to be the member of parliament because that stigma of disqualification of having sentence for 2 years was no more there. Another example I would like to give, that if you are eligible to be employed in government service and you have applied for that job, there is always column, have you ever been convicted in any case? If you say yes, conviction, you are convicted, you are not qualified to be public servant or government servant. But if your conviction is suspended, then you will not carry that stigma. So all the disqualifications attached to the conviction will not be there. That is the importance of suspension of conviction, my friends. And therefore, in rare cases, in exceptional cases, these powers can be exercised by the appellate court, the superior court, looking to the evidence on record, and the court has power and discretionary power, rather I would say, to suspend the conviction. And if someone's conviction is suspended, all the disqualification attaching to the conviction will not be there. So this was the suspension of sentence and suspension of conviction. Thank you, friends. You can subscribe my channel, You can share this video if you wish to continue